I believe with all my heart and all my soul that the day is coming whenever we will see justice and we'll walk out of this place. It may not come tomorrow. It may not come on September 30th, but it will come.
Tonight, Damien Echols and the West Memphis Three might be one step closer to proving their innocence.
That video you just heard was Echols in 2010, right before he, Jason Baldwin, and Jesse Miss Kelly, took what's called an Alfred plea deal.
It allowed them to maintain their innocence while accepting that the prosecutors had enough evidence to convict them of killing 3 boys in West Memphis back in 1993. But regardless of how that arraignment worked, Damien Echols has always maintained his innocence. And so tonight at 10, today that legal fight is continuing with a major update in the case.
This morning, the Arkansas Supreme Court cleared the way to test some evidence from the 30-year-old case. All new tonight, THV 11's Ashley Godwin joins us in studio to break down today's decision and how the Echols legal team is preparing. What's next?
Hey, Faith Rowley, this newest battle in the West Memphis 3 case centers on this evidence right here. A box of evidence that was once thought to be destroyed. Now Damien Echols' legal team moves forward in what they say is justice and knowing who really killed those 3 little boys.
Once that additional DNA testing started pointing in different directions than the 3, then we first started to have real hope that maybe there was a way this case would break open.
Damien Echols' lead counsel, Stephen Braga, has been on the case since 2009. Right before Echols, Jason Baldwin and Jesse Miss Kelly made an Alfred plea deal.
I haven't been involved in another case, anything like this in my career. Believe me, this is one of a kind, really dramatic case in terms of as Judge Laser said at the Alfred plea hearing, it's a tragedy on all sides.
Echols has maintained his innocence since, pushing for justice in the case. And that push came closer to reality in 2021 when evidence thought to have been destroyed was found. Echols and his legal team want to test it for DNA to see if they can identify who was at the crime scene. But when they took it to court in 2022, a Crittenden County Circuit judge said no, and that the petition they filed under was not applicable in this case because Echols wasn't in state custody. 2 years later, the Arkansas Supreme Court weighed in on the decision. In a 4-3 majority opinion, the justices say Echols can test the evidence with this law, and he does not need to be in state custody to seek relief to prove his innocence.
We're going to take the high road and respect both sides, and luckily we won. We're able to go back and have jurisdiction in the circuit court over the petition for new testing. And what I would say to anybody who believes that the West Memphis Three, who still believes that the West Memphis Three committed this crime or Damien is some kind of depraved criminal, well, let's let the testing be done.
Something Echols and his team have been working on for years, and they say they are closer now than ever to finally knowing the truth.
He really hopes that there's a way to expeditiously get this evidence tested. He has no fear of what the evidence might show, but he is still hopeful that someday the real perpetrator will be found.
So Ashley, we are getting closer to that evidence being tested, but how long could that take?
Faith, the case now goes back to the lower court to allow them to respond. Echols' lead counsel believes it will take about a month to figure out how he and the Crittenden County prosecutor will move forward with testing the evidence.
Ashley, all right, a new chapter. We know you've been reading through this book for a lot of years. We'll continue to look to you as we get the new information. Thank you very much tonight.
Hello, I'm Rick Mullinax, and this is Burn After Reading. Joining me today is returning guest Lisa O'Brien of the Based in Fact podcast. And I didn't expect we'd be going over this again anytime soon, but here we are. How are you today, Lisa?
Very well, thank you.
All right, so Thursday, it was an interesting day to say the least. The Arkansas Supreme Court made a decision regarding Damien Echols' request to retest DNA evidence. And anyone not in the know, he's one of the West Memphis Three who was convicted of the murder of 3 8-year-old boys, Stevie Branch, Christopher Byers, and Michael Moore in 1993. And Echols, along with Jason Baldwin and Jesse Miss Kelly, were found guilty, with Echols receiving a death sentence. In 2011, Echols entered an Alfred plea, maintaining his innocence but acknowledging the prosecution's evidence, and was released from prison. Echols sought further DNA testing of the evidence using new technology, arguing that it could potentially identify the true perpetrators of the crime. Previously, the Crittenden County Circuit Court denied Echols' petition for additional DNA testing under Act 1780, ruling that the court lacked jurisdiction as Echols was not in state custody. The court interpreted Act 1780 as a form of habeas corpus relief, traditionally available only to those in state custody. Echols appealed his decision, arguing that the plain language of Act 1780 allows any person convicted of a crime to petition for additional DNA testing to demonstrate actual innocence regardless of their custody status. The Supreme Court of Arkansas reversed and remanded the lower court's decision. It was a 4-3 ruling. The court found that the plain language of Act 1780 unambiguously permits a person convicted of a crime to petition for additional DNA testing to demonstrate actual innocence. The court held that the lower court had misinterpreted the plain language of Act 1780 by imposing a requirement that a petitioner must be in state custody to seek relief under the Act. The court concluded that Echols, as a person convicted of a crime, was entitled to seek relief under Act 1780 regardless of his custody status. So, Lisa, what are your thoughts? You have more experience in law, legal proceedings, and procedures than I do. Did the majority opinion get it wrong regarding Act 1780, or did they get it right?
I think they really, I think they're getting it wrong because they're opening an avenue for people like Echols who have served their time, who now 20 years, 40 years, 30 years later want to challenge their conviction. And so they do it by claiming actual innocence and seeking testing. And now the courts are going to have to hear those and decide those and order those. And then they're going to have to deal with the post testing in the event that DNA from the convicted party is not found, because even though that's not as meaningful as some people believe it to be, it will be argued that they're actually innocent because their DNA was not found. I also think it is weird because 1780 is contained in the habeas corpus statute. So habeas corpus is your remedy if you have that new scientific testing. So I'm not quite sure how Echols, even if it does exonerate him, which it's unlikely to be conclusive enough to do that. I don't know what he's going to do because he can't petition do a writ of habeas corpus because he's not in custody.
And it's not uncommon. Kind of bringing up this possible bottlenecking of having other people wanting DNA testing if they've been convicted of a crime, served their time, and they're out. So, like I said, it's not uncommon that the Supreme Court justices, they don't always agree with each other, and we'll see dissenting opinions from them regardless of their various cases. So, for me, that's always been a little alarming because the law should be clear and precise. And in this scenario, we have a near split when it comes to this decision. Not to mention, this decision is opening Pandora's box, and for any Tom, Dick, and Harry to get new DNA testing, whether they are in state custody or not. Why do you think this was polarizing for these justices? The fact that it was a near split decision, came down to 4-3 in favor of allowing for retesting.
I actually don't think that, even though I know that Echols supporters and Echols himself are probably misrepresenting the majority's opinions, the majority's opinion really didn't address the questions of whether Echols is innocent or guilty. They merely found that under the lower court misinterpreted the language of the DNA testing procedure or part of the statute. But the dissent was very strongly not in favor of Echols, and actually very strongly opinion that he is guilty.
Yeah, and then later on, that's something that I want to go into a little bit more. I want to read a lot of that. And now, as it stands now, correct me if there's anything additional. Damien wants 3 ligatures tested, correct?
Correct.
Okay. And how many times before have these ligatures been tested? When and by who?
They were tested by Bodie back in, I believe it was 2005. And let me just go through my notes. There was on December 30th, 2005, an STR forensic case report, forensic DNA case report was issued by Bodie, and it basically found partial profiles, 3 or fewer alleles from the ligatures, 2 ligatures, one from Steve and one from Michael. But then there were no reportable results recovered from additional evidence, including Chris's ligatures and the 2 ligatures, 2 of the ligatures binding Steve and Michael. MVAC cannot create DNA where DNA does not exist. So if there were no reportable results on 4 out of 6 ligatures, it's unlikely that those 4 ligatures are going to produce anything.
I see. Now, did Genetic Design in the beginning of the West Memphis 3 case, did they do any testing with the ligatures?
No, the methods available in 1993, 1994 were not sufficient to test the microscopic material that might have been found at that time on the ligatures. We also have to remember the ligatures were submerged in water
That's true.
for 17 up to 17 hours. More likely than not, had any material been recovered from any of the ligatures, it would have been the material belonging to the victims, not
And
a perpetrator or a potential perpetrator.
so let me ask you this question, and perhaps the question is a bit speculative, but do you believe it is even remotely possible that we can get conclusive DNA evidence from the or results from the ligatures with the MVAC system? And if so, why or why not?
I do not believe that we will get conclusive results. I believe that the prior results, if there had been material available on the ligatures in 2004, that material would have been recovered and would have been reported in 2004 or 2005. MVAC doesn't create material where none exists. It can't. And it's all speculative as to whether or not this new collection method is going to collect anything. And I think it's highly unlikely that it will collect anything. And if it does, if we get a more conclusive result, it's more likely to be from the victims, not from the perpetrator.
Right. And to go back to what you were saying about these items being submerged in water, not just the ligatures, but basically everything, actually everything. Serologist Kermit Channel. And I remember last time when we were talking, I didn't know if his last name was Channel, Channel, but it's Channel. So I verified it. But anyways, so Channel testified in court. I believe it was in Jesse Miss Kelly's trial, that the effects of water when it comes to physical evidence, he testified that evidence submerged in water or even being dirty or soiled has a very bad effect on any type of biological materials that you might find. Being in the water can make it virtually impossible at times to identify any type of material. And we also have to consider this and clarify anything if I might be getting this wrong. When the victims were recovered, the police had to enter the ditch where the bodies were located, and they rifled around in the water, digging out clothing as well as touching the bodies. This cross contaminated them, introducing hair and fibers to the scene, which hadn't previously been there before, which is surprisingly all too common in criminal investigations. And I would venture a guess that if you were to ask any CSI what the biggest problem they face in the field is, they will most likely say crime scene contamination. And contamination of the crime scene can not only mislead the investigation, it can also be a defense attorney's dream come true, because the clothing and other items would then be collected and set on, the nearby ditch bank, picking up anything that may have been there as well. And I think this does align with Bodie's laboratory May 27th, 2008 letter to the office of prosecuting attorney Brent Davis. But if you were to ask Arkansas Justice Innocence, they would tell you that was Scott Ellington. But anyways, In it, it refers to mixtures regarding penile swabs from, Moore and Branch, and then ligatures used to tie up Branch, and it refers to to potential contamination. The state that the bodies were submerged in water between, I believe it was 18 to 24 hours prior to discovery. They went on to say that it's very unlikely that any interpretable DNA profile other than that due to the contamination or that of the victims would be recoverable. And based on Bodes' analysis letter, it is clear that the data provided is questionable at best. And later in that letter, they would use another term, suspect at best. And in Damien's petition in 2022, it stated something I found interesting. And it stated, and you kind of touched on it earlier, no one knows, of course, whether additional testing of the ligatures, which being the shoelaces, with the new MVAC DNA collection technology will lead to the recovery of new DNA samples for testing or not. But one thing for certain is that such evidence will definitely not be found if testing with this new technology is not done. And I thought that was interesting because when you hear Bob Ruff or the West Memphis 3 supporters flap their gums, they think in their mind that retesting these ligatures with MVAC is going to point to the killer. And ironically, Michael M. Baden, and hopefully I'm saying his last name correctly, the MD director of the Metallurgical Investigations Unit of the New York State Police, and at one time an expert of the West Memphis 3 legal defense team, in testimony before the U.S. Senate Committee on the Judiciary indicated that in less than 10% of murders, the criminal leaves DNA evidence behind, and that's significantly a low percentage. But people think DNA evidence should only be standard to convict someone, and that's not a realistic approach, right? I mean,
No.
if you have it and it's conclusive, that's great. But when murderers don't leave any conclusive DNA behind, we're just supposed to ignore all other forms of evidence. I know I said a mouthful, but I figured, is there anything there that needs corrected?
No, although I'm not as much a proponent of the potential cross-contamination
Hmm.
theory. I think it's pretty unlikely that DNA from investigators in the ditch would have ended up on the bodies, even though it might potentially have been floating around. And in reality, probably any DNA that they shed while in the ditch was washed away from
Okay, so
them more likely than anything else.
so more
But no,
destroyed than contaminated. Okay.
more, yeah. And yeah, I think that at the moment the bodies were placed in water, significant amounts of DNA that might have been left behind. And this is another thing. We don't know. There's no metrics to say how much evidence is left behind in any crime. It's you can't say it's going to be a certain amount. You can't say it's going to be in a rape. It's going to be a certain number of sperm cells in a robbery. I mean, in a shooting, you may have no DNA from the shooter if the shooter and the victim are far away from one another and don't come into contact with each other.
Right.
In a case where, like a person dropping a rock from an overpass and it goes through a windshield and kills the driver, if they wore gloves, they're not going to leave behind any DNA or fingerprints or other evidence that's going to help lead to their identification. So, what's left behind and how much of it is left behind is always a question.
And that's a great point. Like, no, that's a great point because in this situation, if you had people who were driving by and say that the person was wearing very identifiable clothing,
Mhm.
um, say it's a small town, and in that small town, there's one kid, and that one kid, he loves the Detroit Lions. Now, he's not in Detroit, he's living in a small town in West Virginia where they're rooting for the Mountaineers, and they're in this little
Mhm.
small town, and this is what that person is wearing. And when that rock drops into that car window, you know so we have identifiable features to say, even though we didn't get a close look in the face, he's the only kid in this town that wears Detroit Lions gear. And then you find out he tells someone else, yeah, I went ahead and I did it. I
Mhm.
went and I thought it was funny as shit. Because you got those cruel type of people. you can't ignore that kind of evidence. Now, granted, you probably have to have a few more things to add to that. But I mean, we wouldn't ignore that because we say, well, there's no DNA evidence to convict this person. There's no physical evidence. We can't ignore any kind of at the time witnesses that saw what happened when a police report is being filed or they're talking to a prosecutor.
I think that that is a myth created by defense attorneys and somewhat uh, propagated by shows like CSI because they always found the murder weapon, and they were always able to link the murder weapon to the person who committed the murder.
Right.
But that's not how it works in every case. And there are sometimes you do find the murder weapon, but all you can say is that it's consistent and you don't ever find any evidence linking it or putting it in the hands of the accused. But you have a lot of other evidence. And in a case where there is an admission, believe it or not, the admission is the strongest piece of evidence against the person.
Yeah, and let's be honest, even when there is a ton of DNA left at a crime scene by a perpetrator and they go to court, all you have a lot of these people who watch these docuseries like Making a Murderer, they're highly suggestible.
Mhm,
So even though, like for example, in Stephen Avery, like all of Teresa Hallbach's, we're talking about bone fragments. We're talking about like a button from her jeans, the sweat DNA that was on her vehicle, blood, all this other stuff, all things that's DNA that links to Stephen Avery, his other contradictions and lies and all that stuff. Instead of saying, yep, that's the guy, and his nephew assisted, even if it was out of pressure, he assisted with the crime.
mhm,
People want to say, no, no, cop conspiracy, and if it's not a cop conspiracy, it was Teresa's ex-boyfriend because she was jealous, and if it's not the ex-boyfriend, then it's Brendan Dassey's brother because he had some really wicked porn on his computer.
mhm.
That's You can't win even when you have DNA. And then, of course, do I need to even bring up OJ Simpson?
And Rodney Reed.
Yes. I mean, so it really, it's not just watching, even though CSI, that is a big component of it. But I swear, the TV box, the only thing it has to tell you is that a person is innocent, and a big chunk of that audience is going to believe it.
Mhm.
So, was there anything else you wanted to add before I go on to the next question?
No, thank you.
Okay. So, at this point, again, it's another speculative question, but I am curious. Do you think Damien will want other items tested? For example, one of the boys' pants with possible semen on it. Do you think he would be bold enough to have something like that retested?
No, I don't think that he'll try to retest that. I don't think he'll try to retest the necklace, and I don't think he'll try to retest the T-shirt. But I think he will try to retest many other things. Now that he's gotten this pass, and that's the only way to describe it, he's gonna wanna test more things. He'll test this if no reportable DNA results. He'll wanna test some of the boys' clothing. He'll probably wanna test the shirts. He'll probably wanna test anything that dumbass Bob Ruff says he ought to test,
W-
because we know Bob Ruff is all-seeing and all-knowing and smart not. Um, but
Hey, well,
sorry.
wait a minute. No, no, wait a minute.
Come on, Bob,
To,
bring it on.
to come to Bob's defense, you don't understand that he used to investigate fires, and that is equivalent to investigating other, homicide.
I know,
So,
because people could die in a fire.
right. So basically, he's an expert. So,
Yeah.
and also he is solving already solved crimes. So, I mean, this is a very smart man. I don't want to come on this channel, and besmirch him because we just don't need it. No, of course, I'm being facetious. And for anyone, when you hear necklace, the necklace that Lisa is referring to is a necklace that was shared by both Damien and Jason. They both wore this
Mhm.
necklace. And the shirt that you're also referring to was that Jesse Miss Kelly shirt with the
Correct.
little bit of blood. So,
Correct.
yeah. So, for anyone that was wondering, that's what she was referring to. And here's something I hear a lot, and I want your opinion on it. what do you think when West Memphis 3 supporters ask, why not just test the evidence? If there's nothing to hide, if new technology can bring forth new evidence that could either exonerate the West Memphis 3 or reaffirm their guilt, why not just test the evidence unless the state or you are scared?
That is a fallacy. Testing is not a right. It's not a due process right. You're not entitled to it. In fact, you bear the burden when you want testing of showing that the results of that testing would be conclusive and would be a definitive answer to the question of innocence or guilt. And Echols has never really done that. Because he can't. And look at the history of the case. He had a hearing on his motion for new trial with these allegedly exculpatory DNA results, and all of these witnesses telling tales about Terry Hobbs and talking about confessions and washing clothes and believing he did it, et cetera, et cetera. And what did they do? They folded up their tents and they sought an Alfred plea from Scott Ellington, and they entered an Alfred plea and a deal. If DNA really exonerated them at that time, why would they ever seek a deal? Why would they not go through with the hearings, get new trials, and then be exonerated and sue the state for millions? Because that wasn't what was going to happen at those hearings. They were going to lose because the DNA they had was inconclusive. It was never conclusive. The hair is not conclusive, will never be conclusive, even according to Echols' own expert.
And supporters still to this day, they still don't seem to understand that.
They
I
just
get
ignore it.
I get comments on my YouTube channel, like with several of the episodes that I cover with the West Memphis 3, and a lot that I hear are these comments. I will hear, oh, there's DNA that ties Terry Hobb to the crime scene. No, there's not, and that's been well documented. It's not. Even Thomas Fedor, their expert serologist, the West Memphis 3's defense serologist, said it's weak evidence, and even if it was his hair, it's more than likely secondary transfer. It's completely
Right.
weak.
Because an important factor that supporters ignore is that we don't know whose laces were used to tie each of the boys up. They're focusing on the fact that the lace was used. It was found in a lace used to tie Michael, but it could have belonged to Steve.
Right. And here's another thing that supporters will say. That, when you talk, like, when they bring up the Alfred plea, this is what they say. And as a matter of fact, actually, the Arkansas Justice Project, they even echo this lie that Jason, Damien, and Jesse, they took the Alfred plea in order to save Damien from the death penalty, that he was sitting on death row and the state used his vulnerability to push a deal through to ensure that they would never be held accountable and would never have to actually close out the case. That's another fallacy, correct? And if so, why?
Yes. That is a fallacy first and foremost because at the time of the Alfred plea, Arkansas had not executed anyone since 2006. Their protocol was under review. It may have even been involved in judicial review at that time. I don't recall. It certainly was under review with Bays at the U.S. Supreme Court. Secondly, they did not reinstate executions or resume executions until 2017, 6 years after the Alfred plea. So Echols had 5 years, and he would have had 6 more years before he was even close to executions. And again, at the time of the Alfred plea, they had hearings starting in December of 2011 that they were allegedly going to present all this evidence, their allegedly exculpatory DNA evidence, and the witnesses proving that Terry Hobbs was the real killer. Why would they fold up their tents and not do that in December?
And in addition to that, when you're filing appeals or when you have an evidentiary hearing that might lead to a new trial, they're not going to just take you and say, okay, Damien, we're going to go ahead and fry you now,
Mhm.
right?
Correct, correct.
And that's
He
the other thing. Like, they wait until you exhaust all of your appeals. If you do those type of things, they wait for
correct.
you to exhaust all of your rights before, after a while, they finally will say, okay, we're going to set an execution date at some point.
Mhm.
And it's usually pretty lengthy when they decide to do it. But like Ted Bundy, he exhausted all of his appeals, correct?
Correct. And
And did John Wayne Gacy, did he do that? Like, was that the same situation? I don't know if he exhausted all of his or
I
if he just said F it.
I don't recall John Wayne Gacy, but yes, always it's actually you have your direct appeal, you have state post conviction, you have federal habeas corpus, which goes all the way up to potentially the US Supreme Court. And so until all of those things are not have sought an execution date for Eccles because they could not seek execution dates for anyone, even
Mhm.
those with exhausted appeals.
And Lisa, would you mind sharing that again? Only because there was a little cut off. I do
Oh, sure.
apologize.
Eccles in 2011 was not in danger of the state seeking an execution date because it couldn't. It couldn't seek execution dates first because it couldn't seek execution dates against anyone as it did not have an accepted protocol at the time, or their protocol was being challenged. And second, because Eccles still had the new trial hearings and potential new trial. He also, if he was unsuccessful at that, he had a pending federal habeas corpus claim, which would go potentially all the way to US Supreme Court because it would be decided by the district court, appealed to the Eighth Circuit, and then potentially appealed at the US Supreme Court. So he was not in danger in 2011 of the state seeking an execution date. And anyone who believes that he was is just not paying attention to the truth and the facts.
I absolutely agree with that. And I mean, it is what it is. So we know what the decision is, or what the decision, or what the majority opinion is, and I would like to share the dissenting view, which was authored by Justice Barbara Webb. And I was going to read the whole thing, but you sent me a wonderful set of case notes, and I thought you ran the bullet points down beautifully.
Thank you.
Do, do you want to read it, or do you want me to read it?
No, please. This is your show, and I did that for you.
And I truly appreciate it. Like, you have the best notes, you have the great timelines. I really do appreciate it. So, anyways, here it is. And this dissent is shared by Sean Walmack, and also who's a justice, and then also Special Justice Marcia Hernsberger. Hopefully, I'm saying her last name correctly. So the majority's decision obliterates any sense of finality in our criminal justice system. Their interpretation of Act 1780 means anyone who has ever been convicted of a crime, whether or not they be in state custody, can seek DNA or other scientific testing, even if such testing would not prove that individual's innocence. And that is the case here. And here are some bullet point rundowns. Echols' first conviction did not rely on DNA evidence, and no such evidence was presented at subsequent trial because he chose to enter a guilty plea. There was strong evidence of Echols' guilt. Echols knew facts about the case that was not public knowledge. Fibers found on the victim's clothes were microscopic. Oh God, sometimes I mess up my words. Microscopically similar to clothing found in Echols' home. Multiple witnesses testified that Echols confessed to the murders, and multiple witnesses placed him near the crime scene. at the time of the murder. Testing ligatures for another person's DNA will not exonerate Echols. Echols is not entitled to habeas relief for 3 reasons. The writ cannot issue because he is not in state custody. His guilty plea constituted his trial, and his conviction is not subject to collateral attack, and DNA testing would not prove his innocence. I would affirm the Circuit Court's order denying Echols Act 1780 petition. In reaching its decision, the majority ignores common sense and basic legal principles to embark on a fruitless endeavor to exonerate a depraved murderer. Their decision only serves to reopen old wounds for the victims' families and the West Memphis community. So, what do you think are the next steps, Lisa?
The DA could seek rehearing based on the dissent, but it's unlikely that the majority is going to reverse itself. If that doesn't happen, or if that is done and the court declines to rehear it, then it goes back to the circuit court. An order will likely be presented for the circuit court to sign, granting the testing of the 3 ligatures. And then we just wait to see what happens. The order should define how the evidence is going to be handled, where it's going to be tested, who's going to pay for it, and what is going to happen with the results. Although Echols' counsel has previously violated those orders in the first round of DNA testing, the state and the court were supposed to get the results when they were issued, and they never did because they weren't Bodie's client. So Bodie reported to the defense attorneys, and the defense attorneys filed the results that they wanted to file when they filed their motion for new trial and their subsequent federal habeas claims. That's probably what's going to happen with the results, unless it's done at a state facility at state expense.
And what do you think is Damien Echols' endgame here? If he's guilty, and he is, what's his endgame? Because it clearly isn't going to be because he thinks he's innocent.
I think, well, the end game is just to keep himself relevant and to keep an excuse to keep collecting money from supporters. The problem is it's unlikely that there's ever going to be any conclusive DNA to prove anything. In other words, it's unlikely that his DNA would be found, Miss Kelly's or Baldwin's, because again, the circumstances are conclusive DNA results aren't possible because how the evidence was treated when they committed the murders, the time that's passed, and the degradation of the material, what little material may be available. So he'll keep testing, and he'll keep this in the media, and the media will keep painting him as an innocent man, and they'll keep misrepresenting the Alfred pleas and the facts of the case and who prosecuted it. And the new DA who was just elected in 2022, if things don't go his way, she'll become the villain. And he'll just keep going perpetually until he dies.
And it's interesting because you brought up money as being one determining factor. And I'm going to share my screen. I'm going to share a post that he came up with not too long ago. And here it is. Hey, folks, we're going to be putting together a fundraiser to raise money to cover the new DNA testing, which could potentially be started within the next month. I'll keep you posted and send out the link when it's live. We appreciate your help in bringing this to a close. Now, correct me if I'm wrong, if you're in the know, but didn't Bob Ruff already raise this money with?
I thought he did in 2022 and 2023.
Didn't he sell stupid ass t-shirts that said test the fucking evidence?
Yeah, and I thought he offered to pay for it himself when he was trying to get Ellington to agree to it.
Then why does he need money?
I don't know. And I'd like
It's
to know what happened to the money Bob Ruff raised that he claimed was for testing.
I mean, I'm just asking questions. I'm not making
Mhm.
accusations. All I can do is just ask because it is suspicious as fuck.
Yeah. And we
So
had the same issues with West Memphis 3, Free the West Memphis 3 website because WN3.org, because they claim to be raising money for legal defense and legal assistance, and all the attorneys involved were being paid by the state or were pro bono.
that's interesting. Um,
So I think this is kind of the same thing.
that I mean, it's suspicious. It's as suspicious when Jason Baldwin said that he wanted to write a book, and
Mhm.
what did he say? He needed like $40,000 so that he could just sit at home and write this thing. And
Yeah, and I think he raised 30,000 something and there's still no book. And he's been online. In fact, that Arkansas Justice Project shares his Venmo and PayPal because he's in dire straits. And Proclaim Justice is gone, but he's in dire straits.
he asks for a lot of money too. And look, I understand. I do understand that having a murder on your record probably isn't going to be the best thing when you go for a job. But are you telling me, not you, but just generally speaking to people, are you telling me that any of their millionaire buddies couldn't get Damien and Jason a job to
Mhm.
make gainful employment? Sure, it may not be millions of dollars, but at least it would be something you're gainfully employed and you can live your life. And I'm sure some of whoever they'd be employed by would rally to the cause because it's so popular. And I think out of the three, it's funny because I don't know what he's doing now, but it seemed like Jesse was able to have a job and be a mechanic.
Mhm. He has.
I haven't heard him beg for money as far as I know,
Mhm.
at
Nope.
least not publicly,
He's keeping his head down and his mouth shut.
which is probably the smartest thing that he can do is count whatever, lack of a better word, blessings.
Mhm.
Realize you got really lucky and just move on with life. But Damien and to another degree, Jason, they won't do it. And you did you say that the Arkansas Justice Project? Did you say they shared Jason's Vimo, or did you say it was someone else?
They were sharing on one of their posts about the West Memphis 3. I think the one that I sent you
Yes.
first. I think that had his Venmo and all his, and it was urging people to donate to Proclaim Justice, which is no more. So this was written a while back, or it's recent and they don't even know Proclaim Justice is gone. Um, but yeah, they were sharing his Venmo and that he was in dire financial straits and needed their help.
Well, speaking of that, with the article that you shared to me, I want to share what you sent me because it's a banger for sure. So let me pull that up real quick
Mhm.
because this is the kind of people that we're dealing with. It isn't just the bottom feeder West Memphis 3 supporters. These are the people like these fine individuals. Um, Give me 1 second. Present screen. There we go. All right, it's there. So I'm not going to read all of this, but this little section here. The previous prosecutor was Keith Crestman, and before him was Scott Ellington, both of whom are now circuit court judges in the judicial district. You may recognize these names as two of the individuals directly responsible for the West Memphis 3 case. That has become a disturbing disgrace to the second judicial district and the entire state of Arkansas. No, this part is the most disgraceful. Ellington was the original prosecutor on the case who doubled down in 2011 after allowing the wrongfully convicted Echols, Baldwin, and Miss Kelly to take an Alfred plea and be released from prison. Lisa, will you tell me who the original prosecutor was?
Brent Davis and John Fogelman,
What?
both of whom are judges, so they got that part right. But yeah, it was Brent Davis and John Fogelman. And the irony is if Brent Davis had waited until 2012 or 2013 to run for judge, the Alfred plea would have never happened.
I don't think it would have either. And look, I can't hold it against the man to want to advance his, career. I completely understand it. But man, the course of history would have changed
Mhm.
significantly if Brent Davis would have stayed on. And I'm not besmirching him or anything like that. Scott Ellington can go to hell.
Yeah.
But Brent Davis, I appreciate the years of work that that he's done. So it is what it is. Lisa, is there anything else you think we should cover or talk about?
No, I think we have done a good job on this one.
I think so. I think it was blunt, brief, and to the point. I think we covered everything that we needed to. And again, Lisa, I can't thank you enough for coming on. I know it was suggested by someone in the West Memphis Three Facts Facebook group page, and I didn't know if you were going to do anything with it or if you had other things going on, which you do. And coming to that point, what do you have coming up on your podcast?
We are going to be talking next week about Dahlia DiPolito, who tried to hire a hitman to kill her husband, Michael, in 2009. Thankfully for Michael, she was trying to hire an undercover police officer to kill her husband. She was caught and convicted, won a retrial, and then was convicted again in 2017 and is serving her 16 years in the Florida Department of Corrections.
My goodness. And the cases that you cover are usually murder cases that have appeals and things like that, correct?
Correct.
Okay. Is there a better way to maybe word that other than what I just did?
No, that's perfect. I cover cases that have gone through the judicial process with a conviction, a direct appeal, and usually with at least some level of state or federal post-conviction, because it provides me with more resources to get facts of the case
I see.
outside of the media.
And I'm going to try something here. Now, I'm going to put your link in the description page, but let me see if I can make this work
Okay.
here. I was going to see if I could pop up an ad that would show on the screen, but I think that's only when I'm going live. So, but ladies and gentlemen, I will post a description of her YouTube page, and then not just her YouTube page, but also her podcast, which is on any device that has podcasting. That's usually pretty general. I know some of them they're getting rid of a lot of podcast apps. I've noticed,
They
but,
are.
but they're going to be. Her stuff is still out there. I will post a link to both the YouTube and any podcast app that's available. And again, Lisa, thank you. I do appreciate it, and I hope that eventually, man, that there can be some peace in this case because I'm sick and tired of it. I cover it. I cover it a lot. It's for me, it's it's important to put out there. I'm not the first one to put this stuff out here. I hope I'm not the last person to put it out here as long as it's going on. But I appreciate you being one of them to do your thing. And like I said, I'm babbling, but I just
No.
hope there can be some kind of resolution and peace for the families. They got to suffer through this.
Yeah, I do too. And as I said in the Facebook post, I really don't have the emotional bandwidth anymore to devote time on my platform. So I appreciate you continuing to do that. And I also appreciate your support with my podcast. So thank you very much.
No, of course. And there's going to come a time where I'm going to have that same feeling that I don't have the bandwidth to deal with it, and that's why I hope eventually someone else is going to take the baton.
Mhm.
I don't want it to keep going. I don't want it to, but
Yeah.
I think the sad reality is it is going to. And so there have been many people before me who have covered this, such as you, people who have used aliases to discuss it, like Fred J. Walsh. He's brilliant.
Mhm.
Like, he's put out some great stuff. I know Sean Wheeler has put out some great knowledge, and there's some great blogs out there. There's the West Memphis 3 facts page. There's the West Memphis 3 revelations, which is just also very brilliant. There's a lot of good stuff, but I guess unfortunately, if this is going to keep going, I just hope I'm not going to be the last to stand up that the West Memphis 3 are guilty.
Yeah. Well, hopefully we'll all be lucky, and Echols and Baldwin will fade into obscurity, and we can just honor and remember Christopher, Steve, and Michael.
And I hope so as well, but Damien and Jason, they just seem to pop up like cockroaches. But I do agree there needs to be more emphasis on the victims, and sometimes I feel guilty enough that I'm not bringing up those victims as much as I probably should, but they do deserve they do deserve to be acknowledged as the real victims, and children who had a lot of life ahead of them, and it was taken, and that's sad, and it goes the same with other victims. Sometimes we need to cover them more than the bastards who did what they did.
Yeah.
So
Well,
anyways,
they would each be turning 40 this year,
yeah,
I believe,
and I'm
if I
43.
remember correctly. Yeah.
Like, so that's it's a 3-year difference, but man, like,
Mhm.
that's crazy to think about, because sometimes these people, we kind of look at them and it's stuck in like a time capsule.
Mhm.
Like, this is all we know.
Yeah.
And that's absolutely true. So, but of course, the families too, God bless them. Like I said, regardless of everything going on, I still hope that they're able to do their thing, and not have this, lack of a better word, to have it torture them, which, I mean, they've been tortured enough. Let's put an end to this.
Yeah.
All
Well,
right.
thank you again.
Now, thank you, Lisa. And to my audience out there for Burn After Reading Live, I'll catch your ass down the road. Have a good day, Lisa.
Thanks.
Ain't no motherfucker in this world could do it like me. Open up your eyes and insert a little rising.